Elijah? You're not. All right, Elijah Madden, 1302, 1301, 1300, set today for an evidentiary hearing. Council, if you'll state your appearances.
Wayne Vandegraff, Utah County Attorney's Office.
Thank you. And it looks like we, sorry, Council.
Jeremy Shimada, judge on behalf of Mr. Madden.
Thank you. We received an email from the Utah State Hospital indicating that Mr. Madden was refusing to participate today. We do have 2 boxes open from the Utah State Hospital. I'm just wondering if Mr. Madden has changed his mind, if he's going to be here today, or if we're good to proceed.
I spoke with him again. He's still refusing to attend anything but an in-person hearing.
Okay. All right. Thank you for that. Then, Mr. Shimada, I'll turn the time over to you.
And Judge, I don't know if I need to restate my reasons on the record why I believe we can proceed without him today, or
let's do that just because of the circumstances. And we had a hearing, just so we're all clear. We had a hearing a couple weeks ago where we had him scheduled to be here in person. There was a security issue, and so the sergeant would not let him come up, and has made a security decision that is outside the court's hands that he needs to be by WebEx due to the concerns about safety for the bailiffs for the courtroom. So we continued this to this setting, having him be by WebEx, and then he's now refused to be here by WebEx. So Mr. Shimada, go ahead.
And yes, Judge, I believe that we can waive his appearance. He does not want to participate in this specific proceeding. This was a motion that was brought by the state, and it has been extended by my request. Mr. Madden has not had any input into it, so I don't believe that his presence is necessary or his attendance is necessary. I don't think that there's a confrontational issue here. And as Mr. Vandegraff put on the record, there is some case law out there that based on a defendant's non-cooperation with courtroom staff that he can excuse himself from any further proceedings. So with that, Judge, I would like to continue this without his presence.
Thank you. Mr. Vandegraff, is there anything you want to add to that?
No, Your Honor. I think Mr. Shimada stated the case clearly.
All right. Then, Mr. Shimada.
And Judge, just for the record, Mr. Madden is currently found to not be competent. I will note that per statute, it is on the person now claiming that he is competent. It is their burden of proof. However, I do know that both doctors are present, and I'm not sure if the court would just like me to ask them some questions that I have, or if the court would actually like the state to proceed and make sure that they can clear that burden.
Well, and I do realize that it's a state burden. You said he'd been declared incompetent. This time it was competent, just to make sure we're all on the same page. The most recent report indicated that he was competent that he'd been restored to competency. I know that we all have some concerns about that, and given, I guess my question here is, Mr. Vandegraff, is it your position that he is competent to proceed? And if he is, I'll let you begin, and I'll let you both ask questions. But I want to just clarify.
So I would kind of like our evaluators to answer the question I'm about to pose.
Okay.
Since they're the professionals.
And we have both doctors online. Dr. Giles, Dr. Magnell, can you hear me okay? And if so, will you turn on your cameras for us so we know you're there? Okay, perfect. Thank you.
In Dr. Giles' report, which was the first one.
Hang on just a second. TJ, could you change the view so that we can see counsel? I think it's probably difficult to answer questions when they can't see who's talking to them. There we go. Thank you. All right, go ahead, Mr. Vandegraff.
In Dr. Giles' report, which found Mr. Madden not competent, on page 5, the bottom of page 5, he notes, does Mr. Madden have the ability to understand the adversarial nature of the proceedings? Dr. Giles says no. Now, please note that Mr. Madden refused to speak with Dr. Giles. And so a lot of Dr. Giles' assessment came from outside sources, not from Mr. Madden himself. But Dr. Giles goes ahead and says, Mr. Madden lacks the mental organization to be able to recognize and appreciate the adversarial arrangement among the major participants in courtroom proceedings. This is evidenced by his decision to represent himself in legal cases despite having no evidence of legal formal training.
Mr. Deegan and Mr. Hammer, will you mute your microphones because the WebEx picks that up pretty easily, and I don't know that they can hear. Okay, thank you.
He appears to fail to understand the tremendous disadvantage this places him in due to the adversarial nature of the proceedings. Then on page 7 under E, does Mr. Madden have the ability to engage in a reasoned choice of legal strategies? Dr. Giles notes, no, he lacks the mental organization and cognitive clarity to be able to arrive upon reasonable decisions regarding legal strategies and options. While choosing to represent himself in court may not indicate this, his decision to focus on the legal standing of the judge in one of his cases and to decline to participate in competency evaluations indicate that Mr. Madden is not taking the usual and more conventional or reasonable course in his legal defense. So that's Dr. Giles' report. Then we return to Dr., and I apologize if I pronounce this incorrectly, Magnol. If we turn to her report on page 2 in the middle, the summary of opinion. It's my opinion that Mr. Madden is competent to proceed. He does not exhibit any mental health symptoms at this time. Instead, his behavior and beliefs are consistent with those of a sovereign citizen. He does not exhibit competency-related deficits. And he goes through a lot of the treatment that Mr. Madden received at the hospital. What I found particularly interesting is on page 4, in the 3rd paragraph. Dr. Magnol notes that he attends weekly individual therapy that is focused on competency restoration. Treatment notes indicate that Mr. Madden often socializes appropriately with peers and staff, and he consistently demonstrates safe and appropriate behavior. As a result, he maintains the highest privileges. Now, I must admit that that report is in complete conflict with what we have seen in the courtroom. Each time Mr. Madden has appeared, he's been disruptive, insulting, and had to be removed forcibly. That kind of indicates to me that his behavior is an issue of choice rather than competency. Mr. Madden chose to be interviewed by Dr. Magnol. And so I kind of go back to Dr. Giles' notes. And I direct this to Dr. Giles and Dr. Madden, where his behavior is 180 degrees opposite while in the courtroom. Does that indicate a choice, or does that indicate a lack of competency?
Let me hear first from you. Is it Giles or Giles? I know you've been before me a number of times. I'm embarrassed.
It's Giles, Your Honor.
Giles, thank you. Let's have you answer first, and then I'll hear from Dr. Magnol.
Can you repeat the question?
Okay, so in your report, among the reasons you found him not competent was his refusal to consider defense counsel and his behavior in courtroom. But I understand you actually never interviewed him because he refused the interview. Dr. Magnol did actually interview him, found him competent, and even in her report mentions his cooperative behavior and that he has the highest of privileges at the Utah State Hospital. each time that he's appeared here, including 2 weeks ago, his behavior has been 180 degrees opposite from what Dr. Mangold has observed at the hospital. So my question is that a deliberate choice by Mr. Madden to be disruptive and to refuse to cooperate in court? Or is it an exhibition of a lack of competency and understanding?
That's a really good question. I think the way to answer that probably has to do with some of the things that have already happened at the state hospital in terms of ongoing observation.
And Dr. Gus, I'm going to stop you for a second because I just realized that both of you are testifying, and because you're online, I've not followed the procedure and I haven't sworn you in. So
Okay.
I'll have both of you raise your right hand to be sworn. Do you swear the testimony you're about to give in this case to be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Yes. All right, thank you. Now go ahead.
Okay. So, as you're aware, at the state hospital, there's a number of people who are either informally or formally assessing Mr. Madden's behavior over time. My understanding is that he was remanded to the state hospital for restoration of competency, submitted to the program, ultimately was deemed restored to competency. He now met the statutory criteria for competency, and then within subsequent hearings, his behavior was disruptive, uncooperative, and the question, I guess, counsel, you're asking is it possible that that's willful, that's a choice he's making, that's maybe as part of an intentional decision. Part of it, in order to answer that correctly and get a valid answer, would probably be necessary to consider what we call an ABA model of measurement, where we measure and then we have something happen and we measure again. And so it seems to me that the answer to that question would be illuminated by his behavior after return from court. If he was good, and quote unquote, and he was adherent before appearing in court, he was disruptive in court, and then he was adherent again when he returned from the state hospital, that seems unlikely to be explained by a natural mental illness that would show up and disappear and show up again. That seems more like willful behavior, but that depends on his presentation when he returned from the court, I would say.
And do you want to ask him any follow-up, or should I let Dr. Magnell answer the same
I
question?
don't have any follow-ups other than my assumption is, Dr. Mango, you're at the Utah State Hospital, is that correct?
Do you mean my current location, or do you mean my employment?
Your employment. Would you be able to answer Dr. Giles's questions about his behavior after returning from court 2 weeks ago?
Not directly. So I'm employed by the state hospital, but I don't work there. I don't see patients. I don't provide treatment there per statute. And so, I'm all over the state doing these evaluations. And so I'm not located at the hospital. I don't work there per se, though they are my employer. I do, however, have access to treatment notes. And after the last hearing, I looked up his chart because I wanted to know if anything had changed in terms of mental health symptoms. And so I do have access to treatment notes.
And what did you learn when you reviewed those notes?
I learned that Mr. Madden had spoken to his individual therapist, restoration provider, and had talked about what he planned to say and do when he attended court at the last hearing 2 weeks ago, and that he expressed knowledge and understanding that he would likely be dismissed from court, and that he still wanted to go forward. I'm not aware of exactly what happened in court, but it's my understanding that he had very clear understanding of the consequences of his behavior.
Thank you. That answers my questions. I will defer to Mr. Shimada now.
Mr. Shimada?
And I'm going to be slightly different in how I approach this. So Dr. Giles, if I could, in your report, did you determine him to have some sort of a mental health disorder?
Yes, but that was primarily based on other documentation, collateral information, because I maybe spent 8 minutes with him total. There wasn't a lot of information available to me then.
And that's absolutely fine. Can you tell me what that disorder was?
Unspecified bipolar and related disorder. So kind of a general sense that maybe there's some mood swings going on based on things other people have said and treatment he'd had prior.
And is there a cure to your knowledge for this bipolar and any related disorder?
I think cure is a strong word, but management through medication is the standard.
Okay, and can you give me a quick rundown of the environment that you were at when you did this interview with him, or the attempted interview?
Yes, I was at the Salt Lake County Metro Jail. We were in one of the general visiting areas in the jail. It was a barrier visit, so I was on one side of the glass and he was on the other. He came in, he'd already been seated, so he was there, and I approached him and talked to him for a minute. Then he got up and walked away and pushed the button for the door to be returned to his cell and stopped talking to me.
And would you consider, and do you believe, is there any sort of indication that an environment has any role in that bipolar, in the swings that they have?
The county jail is not a great place for people with mental illness. There's a lot of distraction, a lot of difficulty for a person like that. I don't think he was receiving any medical treatment at the jail. I don't think he was receiving any medication at the jail. So it's certainly, if you're asking if it would have caused that, it's hard for me to say, but I certainly would expect those symptoms to be exacerbated because of he wasn't getting treatment, and jail's kind of a chaotic, loud, abrasive place.
So basically, Dr. Giles, it's your understanding that this is all consistent with that bipolar disorder. In a jail setting, he acted in a manner that was very similar to how you would expect a bipolar individual to be acting. Is that correct?
Well, yes. I didn't see him for very long, so I didn't see any mood swings per se, but his comportment was not inconsistent with bipolar. Let's say it that way. It wasn't inconsistent with bipolar, so I didn't see any reason why the previous diagnosis should be questioned.
Okay, and then further, just if he were to get into a courtroom, would that be a setting that's more akin to the state hospital where he's at now, or would that be something that would be more likely to exacerbate the bipolar mood swings?
The court is very orderly, it's quiet, it's calm. Now, transportation to court and waiting for it to appear in court, that could be problematic, but his actual appearance in court, I would say, would be more consistent with state hospital energy, if you will.
And what about it in a trial setting where it's very adversarial? Would he still have that ability to comport himself properly?
That's a good question. I think he could be provoked in that setting. The pressure or the expectation could be something that would maybe exacerbate his symptoms, yes.
So at this point, doctor, based on the collateral evidence that you had gathered, based on how he acted at the attempted interview, it's your belief that he does have that bipolar disorder. Is that correct?
Yes.
Thank you. Now, Dr. Magnol, turning to you, can you kind of tell me what the setting was like when you conducted the interview with him?
Yeah, so I met with him on one of the forensic units at the state hospital. I met with him in a small private room, but it was adjacent to sort of the main common area, so there were distractions occasionally. But we met in a private room.
Would you consider the environment at the state hospital to be an adversarial environment?
I think that's a very subjective question. I think for some people it may feel that way, especially if they feel that they're wrongfully being held at the state hospital.
Okay, and would this be something where they would tend to act out if they felt that way?
That could be one reason that they would act out, yes.
Okay, and just going to your determination that bipolar disorder was not even present in Mr. Madden, you do note that in your report that even if he does have it, it's in full remission now. Is that correct?
Correct. Bipolar disorder is an episodic illness, so we can see long periods of full remission of the symptoms, punctuated by distinct periods of mania, which would include increased energy, a potential euphoria and or irritability, significant decrease in need for sleep, increased goal-directed behavior, racing thoughts, pressured speech, higher risk-taking behavior. And those do not come and go minute to minute, hour to hour. Those are sustained days at a time, usually at least a week would be considered a manic episode. And he has not, per hospital records and per my observation of him, not exhibited any symptoms of mania, which is why I said, at this point, there's insufficient data to support a diagnosis of bipolar disorder. I understand he's been given that diagnosis before. I don't know the circumstances leading to that diagnosis. I only know that he's not currently exhibiting symptoms consistent with mania.
And so then my question at that point would be is I get that you are basically coming down to the conclusion that the sovereign citizen, the thinking there is the main aspect of this. Is there any chance that these the bipolar symptoms that you express about the poor judgment, the risk-taking, is there any chance that the portions that you've heard of the sovereign citizen aspect, where he wants to appear pro se, where he's going to fight this case no matter what, where he doesn't believe he needs the help of an attorney, could those all have been part of the bipolar disorder symptoms from prior that he is now just baked into his own individual sense?
No, so we would expect that risk-taking behavior, poor judgment to be pervasive across contexts, not isolated to only the legal context. And it would be unusual for those to persist in absence of any other manic symptoms.
Okay, and then just the final thoughts that I have for you is you make note that even that there's no delusional belief or no delusional beliefs here because of this belief in a pseudo-legal system. Is that correct, as you stated, as a sovereign citizen?
Correct. One of the defining features of a delusion is that it's idiosyncratic, so it's unique to that individual. It's not shared by a group of individuals, and the beliefs that he has consistently described, which might seem unusual to the average person, are not atypical for the sovereign citizen group. They're actually quite consistent with their beliefs. So if a belief, even unusual, if it's shared within a group, that's not considered a delusional belief.
Okay. Thank you. Nothing further for them at this moment, Judge.
Anything further from you?
No additional questions, but Dr. Giles and Dr. Magnin, thank you very much for the time and effort you spent.
And before you log off, I have a couple of questions. So, and either one of you can answer this, but I think it probably goes to Dr. Magnin's report more. You just indicated that the sovereign citizen beliefs aren't delusional because other people believe in this. And I guess I want to talk more about not just the beliefs, but the behavior that we experienced in court that I think everyone is maybe attributing to that belief. Does that belief, can we distinguish between the belief and the behavior? And I guess the reason I ask that is because all of us in this courtroom have, including both of you, I assume, have dealt with many people who are sovereign citizens. And I don't know that I have ever seen the behavior from any of them on a sustained level and to such an extreme level as I have seen with Mr. Madden. And again, that's just my experience. But how do we distinguish between maybe not a delusional belief, but then a pattern of behavior connected to this belief system that is so abnormal?
Well, I think it's the behavior could be also related to, there could be some personality features at play, but there wouldn't be a mental illness that would account for the behaviors beyond being related to these sovereign citizen beliefs with perhaps some personality features.
And when you say personality features, are you just talking about personality conflicts within the courtroom, or are you talking about personality disorders?
There's not enough there to say that there's a personality disorder, but perhaps I just mean features in terms of, for example, stubbornness or rigidity, features that we all have to varying degrees.
And so in other words, the behavior, if we take away the proposed reason for the behavior being based on these delusional beliefs, you don't see that behavior being a result of any sort of mental illness that would be quantifiable under your standards.
Correct. I think the fact that this is so specific to the legal system and we're not seeing these types of behaviors pervasively in other contexts. I mean, going back to what one of the attorneys read from my report about how he is able to comport his behavior appropriately at the state hospital well enough to have obtained the highest level of privileges speaks to that, the ability to control his behavior, along with the comment that he made to his therapist indicating that he understands the consequences of his behavior. He can think into the future and predict with great accuracy what is likely to happen in response to his behaviors. And so that's just not consistent with a mental illness. That inconsistency across contexts particularly just is not consistent with a mental illness.
And are there other contexts that you're referring to other than court and the experiences with the hospital? Are there other resources that you pulled from indicating that he had consistent behaviors consistent with those of the state hospital in other contexts?
I didn't have access to any other data, so no.
And then, Mr. Giles, or Dr. Giles, I would ask you the same question and your thoughts on that same thing.
Your Honor, could you repeat the question?
It's not a very well worded question. I guess the concern that I have is that we have an individual here who has beliefs that don't qualify as delusional beliefs because there's more than one person that, there's a group of people who have these same beliefs. That aside, however, the behaviors that are associated or justified by these beliefs, self-justified by these beliefs, are more extreme than I think any of us have ever seen in a sovereign citizen constitutionalist. And I guess the concern I have is that those could be attributed, just the behaviors aside, associated with or justified by the belief in this sovereign citizen, those behaviors alone are concerning. And I just want to make sure that there is not a mental diagnosis or mental component to any of those behaviors. Do you see what I mean? I mean,
Yes,
we're not dealing with someone who's just coming in and saying, I don't recognize your authority. We're dealing with someone who has screamed and held onto the podium and assaulted officers. And, it's been...
It's not true.
It's probably the most extreme...
You fucking
I've ever
liar.
seen. And while it's justified by the belief system, the behavior, I think, is different than just the belief system.
Yeah.
So help me understand that.
Okay. Yeah, and I think Dr. Manuel has I think made a very important point to this in terms of kind of the existence or the demonstration of the mental illness across the board. When you have delusional beliefs, they show up in all contexts, at least all contexts that are related to the delusional beliefs, and so where Mr. Madden seemed very much, sounds like at the state hospital, seemed very much in control of his behavior and his ability to navigate through whatever circumstances he found at the state hospital, to the degree that he was in the highest group of privileged patients at the hospital. That's an important thing, because delusional beliefs tend to undermine people's effectiveness, their ability to get along with other people, their capacity for organized behavior over the long term. And if I understand what's been said here so far, his behavior improved over time, which is not something you see with a delusional belief. Now, Your Honor, you brought up his behavior in court, which sounds like it was extreme, and it is possible. I think a better explanation, if given the information I have, which is insufficient, so I'm going out on a limb here, but given the information that's been shared here today, it seems like his behavior in court is better explained by temperament and sort of just aspects of his personality than driven by a psychotic mental illness, because a psychotic mental illness would show up, would be evidenced other places in other ways, particularly over the long term, where he is observed in an ongoing way by Utah State Hospital staff and clinicians.
And is there any, I know that PTSD played a part in the analysis. Is there any part of PTSD and that diagnosis that impacts the behavior in court potentially?
I think potentially, if you can make a connection between his history of trauma and his reaction to past traumas and aspects of the courtroom that are similar to him, you might get some of that extreme behavior.
Dr. Magno, would you like to be heard on that question?
I think we just return back to this issue of the pervasive occurrence of the behavior, right? So with PTSD, we would be looking for a person being consistently triggered in situations that remind them of their trauma. There's not a clear link between, it's my understanding the PTSD comes from his service in the military. Hard to link that trauma with court explicitly, and that the hospital has indicated he has not shown other PTSD symptoms. He didn't endorse any symptoms, and so it would be quite unusual for those symptoms to only manifest within the limited court setting. Which also, to your last question about did I consider other data sources, I had no way of verifying this information, but I did think about the fact that he reported being successfully, honorably discharged from the military, and what it takes for an individual to comport their behavior, to to succeed in a military setting would again suggest the capacity to control his behavior appropriately.
Thank you. I have one final question, and oftentimes when we see these reports and we have a restoration to competency, which maybe is not the right term given the way the first report went, but oftentimes we see suggestions on how to best accommodate the individual during a trial, during court hearings, those type of things. Do you have suggestions that way?
It seems WebEx is probably one of the best accommodations, but it sounds as though the defendant isn't amenable to WebEx, kind of going back to the beliefs.
Well, and he'll have to be here in person for trial, those sorts of things. So if he's here in person, do you have any suggestions on how to best accommodate him if this court finds that he is competent?
Your Honor, I'm unfamiliar with his comportment in court. Did he explain why he was acting out so much?
Because I don't have jurisdiction over him. So it usually ended in screaming and him being removed from the courtroom and resisting that movement. I would note for the record, just so that we have all this on the record, Mr. Madden's daughter, Hannah, is online and has indicated that his behavior was not extremely, I suppose she meant extreme, and called me a liar. So just so the record indicates that. But the behavior, and when I say extreme, my experience in dealing with those who hold the same sovereign citizen beliefs, I don't know that I've ever seen someone maintain this level of behavior, particularly for this long when we're in court and it's holding him in custody, candidly. So that's, I guess, if there are any suggestions, if this court were to find him competent, on how to accommodate him so that we could proceed, because so far we've not yet been able to proceed and he's been in custody for a very long time.
I'm sorry, Your Honor. I'm asking the questions, and it's not really my role, but to be able to answer your question, and I feel like I need to ask another couple of questions.
Sure.
So his refusal to come to court is because he doesn't recognize the jurisdiction of the court, doesn't recognize the authority of the court?
He will come to court most of the time, unless it's on WebEx, but he ends up being taken out of the courtroom because his behavior is not conducive to the courtroom. So there's yelling and screaming and talking over others and holding out to the podium, so he can't be escorted out when the behavior is not conducive to court. Those types of things, screaming, name calling, insults, all sorts of interesting things. And I guess the reason I ask that is just, is there something that you can think of that would better accommodate him for purposes of going to trial?
So that's a very good question, and I appreciate you asking it for his welfare. It's hard for me to provide any valid suggestions. His behavior, it's hard to understand his behavior. You said that he doesn't recognize the court, but then he struggles to remain in court. I can see how that doesn't make sense and would suggest maybe he's not thinking clearly.
Counsel, do either of you have any follow-up questions for either doctor?
I don't have any follow-up, Your Honor.
I just have one briefly for Dr. Magnol. Is this something that with bipolar, could he be experiencing? Because you said the manic episodes don't have to come on. Could he just be going through a long phase without having one of those manic episodes?
Yes, it's possible that if he does have a genuine bipolar disorder, these individuals can go months, years sometimes without a manic episode. So it's possible that he has had a manic episode before and could have one in the future. He's not taking any sort of mood stabilizing medication, but hasn't exhibited symptoms of mania, which is a good sign in terms of maintaining stable mental health functioning.
Okay, thank you.
Anything further?
Nothing, Judge.
All right, thank you both. I appreciate you being here today. You're free to log off. I'll note that Mr. Madden's daughter now said only because BEACAUSE, you aren't keeping to your oath of office. All right, I'll take argument. Mr. Vanderwerf, I'll hear from you first.
Your Honor, after reviewing these reports and listening to both Dr. Giles and Dr. Magnol, it's my opinion that Mr. Madden is competent to proceed. His choice of behavior in court is willful, that it is not a product of mental illness. What I would suggest is that he is returned to the Salt Lake County Jail and we set a hearing to once again go through the Frampton colloquy, and if we are unable to complete that colloquy, to examine the issue, can counsel be appointed to Mr. Madden when he does not want counsel? And I haven't researched that, but I think that's the next step. Thank you.
Mr. Shimada?
Judge, I would point out that my way that I read this, and I know that Dr. Magnol basically said that there's no mental health concerns here, that this is all just a sovereign citizen concern. Dr. Giles, on the other hand, did say that some of these beliefs, some of the manic beliefs that he possesses about wanting to represent himself, that it does tend to lend itself to bipolar disorder. I would also point out, Judge, that Dr. Magnol just stated that this very well could be one of his non-manic episodes for a prolonged period that she is doing this evaluation. Dr. Giles said that the jail was not a place that is conducive and it tends to exacerbate these mental health concerns. So, Judge, my response to that is that I believe that he is suffering from bipolar disorder. I believe that he does express some manic episodes, that Dr. Giles was the one that saw that and recognized that at the hospital or at the jail, along with the civil commitment that he was at prior, which gave Dr. Giles this diagnosis. This is not something that's cured. There's no there's medication management, but he's not taking any of that. Judge, my concern here is that the sovereign citizen stuff is born out of this bipolar disorder where these have become ingrained, and I know that they say that that's not how it works, that this would be established throughout his entire personality, but just with the manic episode that Dr. Giles saw versus what Dr. Magnol's reporting, I would tend to ask this court to find that he's not competent, and then based on the report from Dr. Magnol that there's nothing that's going to change these beliefs, I would ask this court to find him not competent and not restorable, and I would simply ask that he be released from the status, the commitment that he's at. I know that I can't ask this court to dismiss the case. I know that the state does have some time to seek a civil commitment, but that would be our request at this time, just based on the behavior that we've seen here. I believe we can find that there is a bipolar disorder. He does not have the ability to cooperate with counsel. He does not have the ability to testify appropriately. He does not have the ability to sit in a courtroom. So that would be my request at this time, Judge.
Thank you. This is hard because we have all witnessed behavior that is so outside the norm for even those sovereign citizens that we deal with frequently. We have an individual who, for one reason or the other, is not capable of participating in his defense, is not capable of cooperating with his attorney. The problem that this court has is that the first evaluation was essentially terminated without any sort of evaluation, to say the least, I guess. And I realized that the evaluators have limited resources. And so Dr. Giles attempted to determine what was wrong or what the problem was based on the history that Mr. Madden had, which is bipolar. And Mr. Shimada, with regard to the bipolar and the concerns that I think we all had expressed with regard to the most recent report, essentially not addressing the bipolar at all, and not indicating that it was even an issue. I think that Dr. Magnell's testimony today addressed those concerns with regard to the episodic nature and the fact that it can be years, months, however long until you experience that again. I think Dr. Giles has essentially conceded that his report is based only on the historical data, and Dr. Magnell, who is the one who has had a meaningful conversation and evaluation with Mr. Madden, is the only report that I think this court can rely on. I have concerns about Mr. Madden's ability to go forward in this case, and I have concerns about how we're going to get through the case. But based on the doctor's testimony today, I do find that he is competent, that his behavior in this case, even as extreme as it is by choice. And I will make the findings that he is restored and order him back to the Salt Lake County Jail. I suppose, I mean, candidly, I share all your concerns, Mr. Shimada. And I think probably Mr. Vandegraff does too. I just don't think I have enough information to find that Dr. Magnell's report is not valid, and to find that these weren't choices. Now, the word choice with the behavior is an interesting analysis as well, and that there are a whole lot of questions we could have asked with regard to that, but I don't think I have anything before me today other than our own observations and my own concerns that I could validly find that the report is invalid and find that he is not competent because of the report from Dr. Magnell. Now, that puts us in a pickle going forward. I realize that. Mr. Vandegraff, I understand that Mr. Madden does not want counsel, and the problem I have is that the Court of Appeals and the Supreme Court have been very, very clear about the need to complete a valid Frampton colloquy in order to let someone represent themselves. And so we'll try it again and see what the response is. We have made every effort to explain to Mr. Madden that we're happy to let him represent himself if he can answer those questions, and he's refused to cooperate with even the questions. We've also expressed our concern about the length of time that he's been in custody, mostly just because we have not been able to have a meaningful hearing because of his behavior. I know this puts you in a tough situation, Mr. Shimada, because you are acting as an attorney for someone who does not want you as an attorney. And I appreciate that. I know that you are in a bad position. And I appreciate both of your patience with each other, with Mr. Madden, with the court. Let's set it for hearing, and I'll try and go through the Frampton colloquy and see where we are from there. I don't know how else to do it without an opinion from general counsel indicating that I could do something else, and I doubt that that's going to be the case, given the appellate court's position. So, I guess my question for you, do you want an opportunity to speak to him at the jail before we come back? Should I just set a hearing as quickly as possible? What would you prefer?
Judge, I have a handful of thoughts. I am more than happy to try to go down and speak to him at the jail. I had tried to go down previously when he was at the jail and he outright refused there. I did try to speak to him at the hospital a couple of times. He did not return phone calls. He did not indicate he wanted me to visit. So, Judge, at this point, I will go down and try to talk to him again. My suggestion, I've reached out to my office to find out about the standby counsel that we spoke about at the last one. When we read through the cases, that is standby counsel for somebody who is at least willing to work with standby counsel in getting motions filed and issuing subpoenas and at least walking through what my defense is going to be in this case. I do not believe Mr. Madden at this point is anywhere close to that. So it's still our office's policy that we don't be appointed as standby counsel in that matter. Judge, my suggestion would be is to allow him to appear without me present, even in the courtroom next time, simply so that we can get that stressor out of the way so that he doesn't have to see me first and tell me to step away, that I'm not representing him. See if that can possibly help to where we at least are taking that into consideration, that you don't have your attorney right here because we think we're going to try this.
Well, let me just clarify. The sergeant over all the bailiffs has said no way is he coming to court in person, and I can't override that position, and so he'll be on WebEx.
Correct. I'm talking about even on camera, Judge,
Okay.
for WebEx. I will be out in the hallway. That would be my suggestion, and then if I need to come in after, I'm more than happy to come in and do some of the procedural matters, but that would be my suggestion. And so if we can set this as quickly as possible, I'll get down to the ADC to try to see him.
Mr. Andrew, after that?
I think that's a good effort. And if we could set it after December 3rd, I'm going to be out of the country for a couple of weeks.
So my, excuse me, my next calendar after December 3rd is December 4th, or the next one after that would be the 16th or 18th.
I'm available on the 4th, not on the 16th or the 18th.
Judge, would that be an afternoon on the 4th?
I have morning and afternoon. My afternoon tends to be lighter, and so that's why I've put these, but I'm happy to accommodate your
If we
schedule.
could do the afternoon, because I have jury trials set for the 2nd and the 3rd that could go into the 4th.
Okay. Well, let's set it tentatively for 4 o'clock. Does 4 o'clock work? I know you guys are traveling, and that puts you in a horrible situation driving back down in rush hour traffic. We could also do this. We could do it at 1:30 before I start my 2 o'clock calendar, if you want to do that.
Either one works for me, Your Honor.
And do you want to be here in person or appear via WebEx?
I could be by WebEx, Judge, and that way they may not even see my name. He may not even see my name on the WebEx, so that could be.
Okay.
And I'm okay in person or WebEx, either one. It's your.
Well, I'll let you guys decide. We'll set it for on a WebEx day, so you can be either WebEx or in person. I don't care either way, because he will be by WebEx. The only time I have heartburn about someone being by WebEx is when their client's here in jail and they're on WebEx. So I'm happy to do it by WebEx if that's what you prefer. So you choose 1:30 or 4.
I'll defer to
If we could do 4 o'clock then, Judge, if I can appear by WebEx.
December 4th, then 4 o'clock. We'll reset it for scheduling with the goal of getting through the Frampton colloquy. All right. Thank you both.
Judge, can I ask a question?
Sure.
This is Lindsay at the state hospital. So we'll just need a specific transport order to be signed for the jail to come pick him up.
Yeah, we'll do a transport order to send it back to the jail.
Okay.
We already have, actually, so I'm not sure what. Yeah, who knows? Who knows? It's already on the file. So.
Okay, thank you.
If you don't have any contact with the jail, and if there's an issue, will you reach out and we'll resend it over?
Yes.
Okay, thank you.
Okay, thank you.
All right, thank you all.
May I be excused, Judge?
Yes, thank you. Drive safely, you too.
Sorry about that. Oh, it's cool around this cooler over there.
Mr. Deegan.
Good afternoon, Your Honor.
Good
Matter of
afternoon.
Ms. Teresa Larson.
All right.